Tonight we step inside a Georgia courtroom where two defendants face very different crossroads, and one judge isn't pulling a single punch. First up, Quentin Allen Bonds, a prior DUI case, 12 months probation, and a long list of compliance boxes he was supposed to check. But since March and through a chaotic summer, the record shows missed check-ins, new arrests, and program requirements left undone. He says he was hospitalized and even stabbed in jail. The judge not buying excuses. Then, a sharp pivot. Ms. Clark, only 27, a positive cocaine test on probation, but receipts for treatment and meetings in hand. The judge gives a blunt life talk about money, motherhood, and second chances, and then makes a call that could change her path. Watch the pressure build in real time. A stark comparison between non-compliance plus new charges versus a stumble. Paired with effort, as we go, ask yourself, where should accountability end and compassion begin? And when is a judge obligated to drop the hammer? Let's roll.
Judge, you have Mr. Bonds before you.
Raise your right hand for me, Mr. Bonds.
What was that, ma'am?
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
You can put your hand down, sir. All right, so Mr. Bonds, you're before the court on State of Georgia versus Quentin Allen Bonds, 2024 CR 02082. You were before this court for DUI, alcohol less safe, driving on a suspended or revoked license, improper lane change on the 19th day of March, 2024, sentenced to 12 months on probation. You have 6 months and 4 days remaining. Your sentence was told because you failed to report. It says that you are alleged to have violated criminal law by getting the new offense of aggravated assault and battery family violence on December.
This is the fulcrum. New violent charges on December 24th, Christmas Eve. On probation, any new arrest is a red flag. A violent allegation like aggravated assault and battery family violence is a blaring siren. Legally, the threshold at a revocation hearing is lower than a criminal trial. The court can revoke time on a preponderance of the evidence and on probation violations like misreporting. Even without a conviction, the calendar matters. 2. A holiday arrest sticks in a judge's memory because it hints at instability when supervision should be tight. Question for you: should a pending violent case weigh heavier than a stack of technical misses, or should judges avoid reading too much into unresolved charges? Drop your take below.
December 24th, Christmas Eve of 2024. You also have been alleged to have violated the law for suspended or revoked license, open container, no insurance, no tag, expired or invalid tag, unlawful use of tag, defective headlights,
Now layer in the July 14th traffic and compliance pile. Suspended license, open container, no insurance, bad tag, and even defective headlights. On their own, these are lower level, but together they signal disregard for conditions and public safety. Blind spots while on probation. For judges, patterns matter. Administrative offenses show whether a defendant is trying to live within the rules or just rolling the dice. Engagement prompt. When you hear open container plus suspended license while someone is on DUI probation, do you see an honest struggle or a choice to ignore boundaries? And from a policy standpoint, should courts revamp probation to focus resources on higher risk conduct and less on paperwork traps? Sound off.
July 14th of 2024 in Clayton County, Georgia. You failed to report on July 24th, July 30th, August 6th, and within 10 days of August 12th of 2024. You last reported by phone on June 21st of 2024. You failed.
This is the compliance audit moment. Failures to report multiple dates, no proof of alcohol, drug evaluation, anger management, MAD victim impact, AA-NA meetings, and $1,755 unpaid. Judges often call this the roadmap to freedom. Complete the boxers, stay in touch, and you finish probation. When none of the boxers are ticked, courts infer willful non-compliance unless there's strong documentation showing why. Hospital records, treatment letters, or verified obstacles can soften the blow. The key is communication with probation. Viewers, if a person truly can't pay fines or finish programs due to medical hardship, should courts pause the clock or convert to community service? How would you design a fair compliance system?
failed to document an alcohol and drug evaluation. You failed to document anger management. You failed to document victim impact statement with Mothers Against Drunk Driving. You failed to document proof of attending AA or NA. You failed to pay your $1,755 in arrears. Okay, Mr. Lynch, make it good.
Well, Judge, as far as the violations of criminal law, Judge, we would stipulate that there was an arrest. And as far as the reporting, my understanding is that at some point he was hospitalized and communicated that to Ms. Chang. I'm not excusing any unreported, any missing of reports, but I know that at some point he was hospitalized. And Judge, that's where we're at.
Defense strategy here is mitigation. Acknowledge the arrest exists, don't fight the obvious. Then humanize with hospitalization. But mitigation only works when it connects to dates and duties. If you were laid up, who called probation? Where are the discharge papers? Did anyone ask for extensions? Judges are receptive to hardship when it's documented and while the defendant remains reachable. Notice counsel's careful phrasing, not excusing the misses. That's honest lawyering and preserves credibility, but it also telegraphs that the paper trail may be thin. Engagement cue. What documentation would convince you? Hospital admission dates. Doctor notes limiting mobility. Approbation officer's log confirming contact. Tell us what good proof looks like to you.
All right, what's the recommendation, Ms. Chang?
Morning, Your Honor. Probation recommends that 90 days be revoked and close the case.
Nah, we're going with 6 months.
This is a decisive judicial pivot. Probation recommended 90 days revoked, but the judge escalates to 6 months and effectively ends the discussion. Why? Think pattern, plus credibility, plus public safety. Courts weigh whether shorter stints have failed. To correct behavior, the judge emphasizes prior instructions. I gave you the perfect prescription. In other words, the warning shot already happened. If a defendant ignores the plan and adds new arrests, judges often conclude that community supervision isn't working right now. Do you think the court should have accepted probation's lighter recommendation, or was the stronger sanction necessary to protect accountability and deter future violations? Comment your verdict.
Revoking the balance. Case closed.
Judge,
Yes.
can I have one moment?
Sure.
Your Honor,
Mm-hmm.
Mr. Bonds wants to address the court if he may.
Sure.
Yeah.
I'm listening.
Bonds speaks from the heart. Hospitalization, bed rest, even stabbings in jail, and a plea for mercy. Defendants' statements can help, but only when they bridge the gap between hardship and missed obligations. Who did you notify? When? And how do those events cover each missed report? Judges aren't fact-finders on pain alone. They're timekeepers on compliance. Procedurally, if he had timely medical proofs and a paper trail of calls, this allocution would land differently. The judge's body language and tone suggest fatigue, with excuses that don't match the timeline. Question: should courts grant a short continuance to verify medical claims before revoking, or does the track record here make delay unfair to the system and community?
Ma'am, I was hospitalized for a month and on bed rest for 2. That's why I missed most of that stuff. I was supposed to be getting my foot amputated. Then that's why I missed most of my stuff, and I had related that to Ms. Chang.
You say you were hospitalized for how long?
A month and on bed rest for 2.
Okay, you've been missing since longer than that, sir.
And then, not only that, with being said, that's the main reason why I missed most of the stuff. And like last Thursday, and even in county jail, I was stabbed twice over my thermal and boxers. So I'm really asking to throw myself at the mercy of the court and not spend that much longer in here because I don't want to die, really. But yeah, I'm still bleeding and stuff from that. My jumpsuit still has blood on it from that day. I mean, this is really.
Sir,
This is the probation playbook in one line. Even if you can't do the other stuff, keep in touch. Reporting is the lifeline. Many defendants think unfinished classes equal automatic jail, but proactive communication can buy time, restructure payments, or switch to accessible programs. The judge highlights two arrests since June and the silence in between. That silence is what kills credibility. Practical tip for viewers on probation: set calendar reminders. Save your officer's email and send confirmations after calls. If you're hospitalized, authorize someone to contact probation and collect paperwork for you. Engagement cue: is it realistic to expect perfect communication during a medical crisis? Or should probation provide designated medical liaison protocols? What would make compliance humane yet firm?
Gave you the perfect prescription for how to stay out of jail. The last time you reported was in June. Not only have you not reported, but you've been arrested twice since then. I gave you the perfect prescription for how to stay out of jail. Keep in touch with Ms. Chang. Even if you have trouble doing any of the other stuff, keep in touch with Ms. Chang. And Mr. Bonds, I guess, my husband says it all the time. He was like, "Oh, you do a lot of talking." I'm not wasting my breath on you, sir. 6 months, 4 days. Balance will be suspended. Will be revoked. And I'm telling you, Clayton County Jail ain't where you want to be, but you did nothing, absolutely nothing to help yourself.
I did contact Ms. Chang and tell her I was
June 21st was the last time she heard from you.
And I was hospitalized on bed for that amount of time. That was 3 months after that date. And I explained that to her. I'm supposed to be getting my foot amputated in January. I could lose my whole leg if I stay in for 6 months.
The judge underlines a timeline contradiction. If you're too incapacitated to report or complete programs, how are you out and about on December 24th getting arrested on a serious allegation? That contrast undercuts hardship claims. In revocation land, perception of honesty matters as much as facts. When stories don't align with dates, sanctions spike. Takeaway for defendants: if a relapse or crisis happened, own the inconsistency and explain it with specifics. Vague appeals to sympathy rarely move the needle. For the audience, should revocation decisions weigh more on new dangerous conduct than on technical
ma'am, if you can just please give me
but you were okay on Christmas Day to be arrested for some ruckus.
But okay.
Don't tell me. I don't want to know. All I know is you got arrested Christmas Day. So the day before Christmas. So at this point, sir, I'm not changing.
With that, ma'am,
sir,
I don't even know.
The court has no more mercy today. All right, Ms.
New case, new stakes. Ms. Clark, age 27, facing a prior case with simple battery, obstruction, theft of services, and while on probation. A positive cocaine test, déconseil, those 1024 plus failures tied to counseling, AA, NA, and $650 owed. Key difference. From bonds, her attorney arrives with proof, not perfection, but participation. In revocations, judges look for trajectory. Are you moving toward compliance or away from it? A single positive test is serious. But if treatment starts promptly and meetings are documented, many courts treat it as a lapse rather than a collapse. Engagement cue: should first documented relapses trigger short custodial sanctions, or are treatment...
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right. So you can put your hand down. You're before the court on 2024 CR 07413. You were before this court on the 17th day of September 2024 for simple battery, obstructing an officer, and theft of services. You had 8 months and 2 days remaining. Says that you failed to avoid injurious and vicious habits. You tested positive for cocaine. On December 11th, 2024, you failed to comply with counseling, substance abuse counseling as ordered. You failed to attend an AA or NA meeting 1 per week as directed, and you failed to pay $650 in arrears. All right, Mr. Taylor, what's going on?
Your Honor, we do stipulate to the positive test for cocaine. Regarding the failure to comply with counseling and failure to attend NA meetings, Ms. Clark has proof of taking the classes. I don't believe she's completed or the substance abuse treatment program. She has proof of attending to provide Ms. Chang and proof of attending the AA meetings. So that's the current. She's she lapsed.
How old are you, Ms. Clark?
Ma'am,
How old are you?
I'm 27.
All right.
Oh my God, what happened?
No, you're good.
Oh.
This goes out sometimes, but you
Okay.
can still see the judge here.
Okay.
27, Your Honor. And my understanding is there are some fines that are in arrears that she has indicated to me that she will be able to pay or make payments towards.
Yes, sir.
Ms. Clark, you have a job?
Yes, ma'am. I do a little bit of dancing at night. I dance, so I didn't indulge, but thank God, like in any alcohol, because I know that's the reason why I was on.
Ms. Clark, you dancing, but they don't serve cocaine at the clubs. I used to represent clubs, so I know that they serve alcohol, but they don't serve cocaine.
Yes,
What I'm telling you is,
This is courtroom coaching you rarely hear on TV. The judge separates the job dancing from the choices around it, how you manage money and risk. The message is practical. Use fast cash to buy stability, safe car, savings, maybe a home. Not to fuel chaos. For probationers, financial stability directly supports compliance, rides to meetings, childcare, program fees. The judge also zeroes in on identity. You may not have dreamed of this job, but you can leverage it to build the next chapter. Viewers, weigh in. Should judges give this kind of life advice from the bench or stick strictly to sanctions? Personally, I see it as accountability with a roadmap.
you're on probation. You have a responsibility to stay out of jail. Now, I don't mind you dancing. I mean, it's good work if you can do it. But then the money is good. But the problem that dancers have is y'all don't know what to do with the money. It's easy come, easy go. You never get set aside enough to take care of you when you can't dance anymore. When you get tired of dancing, you never buy anything that's going to last. And so because the money comes in fast, you live a wild life and you spend it fast. What I'm telling you is, if I know dancing ain't somebody's goal growing up, like, oh, I'm gonna grow up to be a dancer. But if that's what you do it and use it to better yourself and get to the next step.
Yes, ma'am. I hear you. Like, so,
Instead of just, bringing the money in and letting it go right out, instead of spending it on things that don't last, spend it on something you can use. Stack that money and buy a house. Don't buy no flashy car that's gonna be gone, or that's gonna waste your money. As soon as you drive it off the lot, it's worth a lot less than what you paid for. Buy a good, serviceable, usable car so you can get back and forth to work, and start thinking about the moves you're gonna make in life. The first move being you're gonna stop using cocaine, because that's gonna shorten your dancing career. You got me?
yes, ma'am.
Am I making sense?
Absolutely. Crystal.
Do you know people who have suffered and not done what they need to do in the position you're in?
A lot of people.
So why do you want to add yourself to that? I don't look down on people who dance. That's a job.
Yes, ma'am.
But you use jobs for what they're supposed to be for, to get you to a next level, to make your life better.
Yes,
Do you have kids?
yes, ma'am. I have an 11-year-old daughter.
Okay. You have an 11-year-old daughter. Your daughter does not need a mama who's turning to cocaine. You got me?
Yes, ma'am.
You can explain the dancing. That's work. The cocaine, you can't. And as long as that's in your life, she probably won't be in your life. Who's caring for her?
My mother.
Okay, here's another secret. Your mom does not want to be the full-time caretaker for your daughter. When you go to jail, when you're not able, when you're not available to be there to do the homework, to walk her to school, to make sure she's taken care of, that she has what she needs, that falls on your mom. If your mama wanted another baby, she could have had one. She did not. She's doing that because she loves her granddaughter, but she doesn't want to have to do it.
Yes, ma'am.
You got me?
Yes, ma'am.
So you need to straighten up and fly right. You got somebody who's looking up at you, who's depending on you. You need to use that money for what it's for, to make sure she has stability in her life.
Yes, ma'am.
Do you consider yourself a good mama?
Absolutely.
Okay, then good mamas make sure that their kids are safe, secure, and not wondering where they are at night. You hear me? So you're in jail, she's wondering what's going on. And you know some nosy family member has told her all about what's going on because they can't keep nothing to themselves.
Yes, ma'am.
So you need to get back on track. You hear me?
Yes, ma'am.
What's the recommendation, Ms. Chang?
Your Honor, probation recommends 6 days be revoked, credit for time served since January the 8th, return to probation under the same conditions.
All right, Ms. Clark.
Notice the contrast with bonds. The judge spells out why Ms. Clark earns a lighter outcome, effort evidenced. She brought proof of classes and meetings, didn't pick up new charges, and appears to be engaging with treatment. Then comes a powerful insight, many substance issues traced to bereavement or trauma. The court isn't doing therapy, but it can steer people there. Practically, therapy plus structured probation reduces repeat violations more than jail alone. The judge's condition test at each report is accountability with support. Viewer question: do you agree that measurable effort should offset a positive test at revocation? Or should any drug use on probation trigger automatic jail to protect the court's authority?
The reason people can't have come out here and I've been dropping the hammer on revoking 6 months, revoking 90 days. The reason I'm giving you a break is because you came in here showing that you had at least gone to some of the programs I ordered you to go to. You understand? You have made an effort on probation to do some of what I asked you to do. All right? You didn't go out and get another charge. You did do something that's going to harm you, not somebody else, but you started on what I asked you to do. Be diligent about getting through with what I asked you to do. And the reason that certain things are in there, the counseling session, is because you need to be the best person that you can be so your daughter has the best mama she can have.
Yes, ma'am.
And those are things made to help you think through those issues. You understand me?
Yes,
Let me let you in on another little secret. I always think that when people turn to substances, it usually is because of one of two things: bereavement or trauma. You either have lost somebody very close to you and you're having trouble coping, or you have a trauma experience in your past and you have not dealt with it and you are having trouble coping.
Yes,
Do you
ma'am.
understand?
Yes, ma'am.
Counseling is there for you. Take some of that money and find you a therapist
Yes,
so
ma'am.
that you can get on the good path. There is nothing wrong with therapy. Been there, done that. Okay?
Yes, ma'am.
But don't let somebody tell you, oh, you're not crazy, you don't need that. No, you're not crazy. But you want to be the best mama that you can be for your child, and you want to think through the issues and work through whatever has you stuck, whatever has you thinking that, let me just check out for a minute, let me take this cocaine. Whatever that is that has you stuck where you can't save this money and move on to the next part of your life. Don't be that cliche of the dancer who never lets it go.
Yeah.
Okay?
Yes, ma'am.
All right. So I'm going to accept your plea. I'll sentence you. I'll revoke 6 days. I'll give you credit for time served. You'll go back to probation and complete the balance of your probation conditions. Did you order any, and you'll test at each report?
Yes, ma'am.
All right, Ms. Clark, you got a baby. You got a child. She needs you. Every time you think about doing something stupid, her face should pop up in your head. You understand?
Yes, ma'am.
All right.
And
Ms. Chang, anything else?
yes, Your Honor, just to give Ms. Clark her next appointment for this Thursday, January 16th at 1:45.
Stuff that you've done, even if it's not finished,
Mhm.
bring proof of it to Ms. Chang.
Okay.
What was that time and date again, Ms. Chang?
January 16th at 1:45.
All right, Ms. Clark, you know I understand the game, right?
Yes, ma'am.
I tell you, I used to represent clubs, so I probably represented 4 or 5 of them.
Yes, ma'am.
Don't get caught up. All right? All right, going back with the sheriff's office.
Thank you. You have a good day.
Thank you, Your
You
Honor.
too.
2 defendants, 1 bench, and a clear theme. communication plus documented effort drive outcomes. For Mr. Bonds, the judge revoked 6 months due to missed reporting, missed programs, unpaid assessments, and critically, new arrests that shattered credibility, including a December 24th violent allegation. His hardship claims lacked the documentation and timeline alignment the court needed. For Ms. Clark, the court sees a relapse coupled with verified steps toward recovery, proof of classes and meetings, no new offenses, and a willingness to engage. Result: 6 days revoked with time served, back to probation under prior conditions and testing. Takeaway: on probation, show your work. Every call, receipt, and session matters. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.